Abubakar said this today before the committee to explain why the Senate leadership is in court. He said if any case is pending before court of law, no other arm of government is expected to look into or take any action on it, and it will be prejudicial for him to make any conclusion on the matter. The AGF stated that as the number one law officer, he has the constitutional mandate to sustain the democratic process in line with Section 174, subsection 1.
But then the position of law is clear. That when a matter is pending before a court of law, neither the executive nor judiciary is entitled, nor the legislature is, neither the executive nor the legislature is entitled as a matter of law and practice and convention to look into it.
The case that was instituted against the leadership of the Senate by his office was instituted at the instance of some 7 senators, and according to him, it was instituted after the conclusion of police investigation.
Unfortunately for the Attorney General is a party in the case, in the prosecutor. In as much as the Senate is not a party to that case, the Senate has the latitude and privilege to comment without sanctions. But for the AGF, that comment is not possible against the background of the principles of sub judice.
Reacting further, the AGF stated categorically that his decision was based purely on public interest, in the interest of justice, and does not amount to dabbling into the affairs of the Senate. The Senate Standing Order of 2015, as amended, did not follow the standard procedure of the Senate. Chairman of the Senate Committee on Judiciary, Human Rights and Legal Matters stated that Section 62 of the 1999 Constitution gives the Senate the power to make rules to regulate its own proceedings, and that their mandate is not to look at the cases pending in court, but events that precedes the case, which are interior and exclusive to the Senate.
That you have these cases that you have mentioned pending, that we have the criminal matter was eventually filed when those ones were pending. That we are looking at the totality of all these factors. I'm just trying to reemphasize, but if what has been said is clear enough for you, we would allow you to respond.
The Senate Standing Rule of 2011 was amended as a result of Senate resolution passed during plenary, indicating areas that needed amendments as agreed to by all. But this was not the case with the 2015 amendment, making it necessary to institute the case.